No, I have spoken to him earlier about this. So he does not have any problem with that. I have spoken to him
What
earlier.
he will say is, I have already made my submissions. He shouldn't say no. First, you keep it under the caption to be mentioned. Not tomorrow, day after.
Yeah.
Let it come. Then
Great. Shall I give the number? I will give in 5 minutes. Great.
Audience side daily list item number 1.
I'm appearing in this case, my lord. The matter was served, my lord, was returned back with the endorsement. Address cannot be located.
68.
68, yes. My lord, there's a delay of 177 days, my lord.
That can be condoned. What is
My lord, email service and lordship. My lord, my lord, genuineness and creditworthiness was not proved, my lord. Lordship will kindly come to the assessment order. Lordship will find, my lord, page number starts at page number 10, page number 13, my lord, paragraph 3.1, my lord, from the top 11th line, my lord. It is seen that the SSC has shown listed subscribes paid up. SSC has shown issued subscribed and paid up share capital of rupees 70,70,000 on a issue of rupees of 7,007 equity shares of 10 rupees each. The SSC company floated 6,97,000 shares of rupees 10 each, or premium of rupees 190 per share. The share worth rupees 10 were issued the huge premium of rupees 190 per share, which has no justification considering the far from the impressive track record of the SSC company, which was incorporated in the same year under consideration for the assessment. Thus, the SSC had received a security premium amounting to rupees 13 crores and odd against such shares during the financial year 7-8. The premium was not justified in the face of a negligible profit of the SSC company and the absence of any credit worthiness, worthwhile track record of the business, the turnover and the profit, the genuineness of the share capital and the and the reconcilable of the share premium was not established. Thus, the circumstances of the appellant's case are similar to those relating to the modus operandi of introducing concealed income oblique money through the web of various companies involving issue of an investment of a bogus share capital, inclusive of the bogus share premium, and it is clear that the SSC had introduced its own unaccounted funds in the garb of a share application money. The SSC has not been able to discharge the onus of proving that the case is different and the share capital was genuine and the charging of premium was issued, shares was justified. The entire share premium application money of rupees 13 crores was liable to be held as unexplained cash credit under section 68. This is the assessment order. If your lordship will kindly come to the CIT's observation, your lordship will CIT's order starts at CIT's observation is starts at page 33. Observation is page 56. If your lordship will kindly see page number 56, CIT's observation, paragraph 6.2. Decision. I have duly perused the assessment order, the statement of facts, and at the outset, the assessing officer had passed an order under section determining a total income of rupees 26,000. Subsequently, during the course of proceeding 263 by the CIT appeal, the Kolkata observed the proper inquiries and examinations were not conducted by the assessing officer during the course of assessment proceedings in order to verify the genuineness and the source of share capital as well as identity and creditworthiness of the shareholders, which rendered the assessment orders erroneous and prejudicial to the interest of revenue as per the provision of section 263 of the Act. The CIT had set aside the impugned order.
Sorry for interruption,
my lord.
After 13 years, is it not unreasonable? There was an 143.3.
Yes.
Then 263 order.
Yes.
Reassessment proceedings.
Yes.
3 volumes paper book they had filed.
Yes.
And after a gap of the matter pertains to the financial year 12-13.
Yes.
Sorry, 2007-8.
7 assessment year. Yes. Financial
almost 13 to 14 years.
Yes.
Unreasonable, sir.
My lord.
Please come. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the act is directed against the order dated June 21, 2024 passed by the Income Tax Appellate Tribunal B Bench Kolkata within bracket tribunal in ITA numbers 160 and 161/KOL/2024 for the assessment year 2008-9. The revenue has raised the following substantial questions of law for consideration: A, B, and C in page 5. D not required. We have heard Mr. Procedural, learned senior standing counsel, appearing for the appellant revenue. The notice sent to the respondent has returned. Considering the fact, no, there is a delay of 177 days in filing this appeal. As the delay has been properly explained, the same is condoned. Application in GA1 of 2025 is allowed. Para. The assessee preferred the appeal before the learned tribunal, challenging the order passed by the appellate authority dated 29/11/2023, affirming the assessment order passed under section 143 within bracket 3, and also assailed the correctness of the order of the penalty order passed under section 271 within bracket 1 within bracket small c of the Act. The assessing officer made the addition under section 68 of the Act for unexplained share capital during the year under consideration. The assessee company floated 6,97,000 equity shares of rupees 10 each at a premium of rupees 190 per share. Initially, the assessment was completed by the assessing officer, accepting the stand taken by the assessee. Subsequently, an order was passed by the commissioner under section 263 of the Act, and pursuant to the directions issued, the assessing officer reopened the assessment and called upon the assessee to explain the nature and source of the alleged sum to his satisfaction. The assessee, it is not in dispute that the assessee had filed complete details of each of the share subscribers to prove the identity and creditworthiness of the shareholders, and the genuineness of the transaction was proved by producing copies of the confirmation letters, bank statement, audited financial statements, identity proofs, source of funds, investment by the share subscribers in the assessee company, the replies which were given to the notice issued under section 133 within bracket 6 of the Act, and various other details to show that the shares, most of the share subscribers have also passed through scrutiny proceedings. These details were placed before the learned tribunal by way of paper books in 3 volumes. The learned tribunal has extenso referred to the details contained, details which have been furnished. Furthermore, the shareholders have responded to the notices issued under section 133 within bracket 6 directly to the assessing officer, and their respective assessment orders framed under section 147/143 within bracket 3 of the Act were also placed before the assessing officer as well as before the learned tribunal. Thus, it is evident that the assessee has produced all the documents before the assessing officer not once but twice, and the authority, except indicating a theory of routing of entries of paper companies / shell companies, no discrepancy had been pointed out in the financials of the alleged cash creditors. Furthermore, all the share subscribers are private limited companies duly registered with the Ministry of Corporate Affairs and have been furnishing the audited financial statement in the portal of the ministry. That apart, the share subscribers have also demonstrated that there was immediate source of funds available in the bank accounts, which have been applied for making investment in the equity shares of the assessee company. One more important factor which cannot be lost sight of is that the matter pertains to the financial year 2007-08, and the scrutiny assessment was completed on 27/9/2021. The full stop. After a gap of 13/14 years after the actual transactions had taken place and final assessment orders have been passed, proceedings were initiated. The predicament faced by the assessee was taken note of by the learned tribunal, and it has observed that it is practically difficult that after a gap of 10 to 12 years, the assessee can call the share subscribers who invested long time before, and there is every possibility that though the shareholders would have sold their equity and new shareholders would have taken their place. This Truman Consultants, one judgment is referred, Mr. Doria.
Yes.
Are you carrying that? This is our judgment.
Your lordship, has dismissed the appeal, my lord.
The tribunal also took note of the decision of this court in Truman Consultants Private Limited versus ITO in ITA number 1158/KOL/2023.
Right? No, I don't.
No. This is tribunal's order.
Tribunal's judgment, my lord. Thereafter, my lord, we have preferred an appeal against your lordship has dismissed. That, my lord,
Where an identical issue. No, don't strike.
Truman.
Let it be there. The learned tribunal referred to the decision of the coordinate bench in the case of Truman Consultants Private Limited versus ITO, ITA number 1158/KOL/2023, wherein identical issue of unexplained share capital from various share subscribers came up for adjudication, and after considering the factual aspects and following the judicial pronouncements, the appeal filed by the assessee was allowed by the tribunal. The revenue, you got the number?
Right now, my lord.
All right, you give it later.
Yes.
The revenue preferred appeal before this court in ITAT number so-and-so of so-and-so, and by judgment dated so-and-so, the appeal filed by the revenue was dismissed. Thus, we find that the factual issues have been thoroughly adjudicated by the tribunal.
Truman.
Apart from noting that the assessee had been put to multiple levels of scrutiny, and the assessee was able to bring on record documents in support of their claim. Therefore, we are of the view that the addition made under section 68 was rightly ordered to be deleted. For the above reason, we find no grounds to interfere with the order passed by the learned tribunal. Accordingly, the appeal fails dismissed, and the substantial questions of law are answered against the revenue.
ITAT number 203 of 24.
203 of
24.
2024. What is the date of the judgment? Ask her.
25th April 25. 25th April.
I have written. Once you check and then do it. Next.
Number 2. But I'm appearing in this case, not. We have served, my lord, they have received that. There was a delay of 80 days, my lord. So, Here also, my lord, 68 reopening was done. My lord, SSC has taken unsecured loan.
Drafting the grounds, will you not get bored? 68 from morning to evening 68.
My lord, here the SSC has taken unsecured loan of rupees 48,000. Those loans was treated as an unexplained cash credit, and my lord, addition was made. If your lordship will kindly see, my lord, page number assessment order starts at page number 10. Lordship will kindly 11, page number 13, my lord. The SSC company has taken unsecured loan from Mrs. Nikhil Holding Limited during the financial year under consideration. Mr. Muralidhar Lohati was one of the directors of the Nikhil Holding and has accepted the statement of record 134 that the Nikhil Holding Private Limited is only a shell company which is being not run to provide accommodation entries to the various entry providers. List of the beneficiaries were provided, who has taken the accommodation entry from Nikhil Holdings Private Limited. And in answer to the questions of 19 of the statements, as Sri Muralidhar Lohati SSC company is one of the beneficiaries who has taken unaccounted accommodation entry of rupees 40 lakhs as per the statement of Sri Muralidhar Lohati. The SSC has claimed a loan amount of rupees 40 lakhs as a genuine transactions as the same has been received through banking channel. However, the same was not accepted by the company from whom the loan has been obtained. Is a shell company as per the statement of its own directors. Therefore, the question of genuineness of loan of the shell companies does not arise. The only deception of the loan entries was being unaccounted money into the bank.
We'll adjourn the matter. Let Mr. Surana appear.
Yes, but delay may be condoned below. 80 days delay. We have served, they have received.
We have heard so and so. Learned Senior Standing Counsel appearing for the revenue, appellant revenue. The respondent has been served and affidavit of service has been filed. None appears for the respondent. There is a delay of 80 days in filing the appeal, as the appellant department has shown sufficient cause for not able to prefer the appeal within the period of limitation. The delay is condoned. GA 1 of 2025 is allowed next week.
Grateful.
You please inform Mr. Surana.
Yes. Grateful.
My lord, in this, there is one mistake happened, my lord. My lord, remember in matter, wrong copy was served to SSC. See the effect of this matter. This matters copy was served to in that matter. But however, my lord, later on, I had sent the soft copies.
My lord, I am seeking leave to appear virtually, my lord, for the respondent.
And
Yes, my lord.
both are
Yes, my lord. I am seeking leave to appear virtually in this matter, my lord.
Most welcome.
And for the respondent, my lord.
Soft copies also.
Now, have you received a copy of the appeal papers?
Yes, my lord. Yes, my lord. Yes, my lord.
Well, there is a delay of 80 days.
That can be condoned. What is 147?
147, my lord, the survey was conducted in respect of School of Human Genetics and Population Health. On the in that survey, my lord, the key persons of that trust had accepted that they used to provide accommodation entries in lieu of commission. On the basis of such information, the case was reopened. But the tribunal has held that the assessing officer has reopened the case on the basis of borrowed satisfaction.
And
My lord, this case is below the tax effect also, my lord.
What is the tax effect?
My lord, tax effect is low, but this is under the exception clause.
But then the tribunal says that the CIT appeals accepted the donation as genuine for the assessment year 13-14.
My lord, can you appreciate one fact, my lord? This exemption, permission to accept donations, was withdrawn retrospectively.
That is wrong.
My lord, this is the recorded by the tribunal also.
Page 37 is recorded. Donation
Kindly come to page 37, my lord. Para 8. In the middle portion, my lord, we note that the said exemption granted to the said institution to accept such donations was withdrawn on 15/9/2016.
I think that was put to challenge.
My lord, the School of Human Genetics, they went to settlement commission before they accepted that they used to provide accommodation in prison, my lord. And my lord, there are 2 cases in my as per my knowledge, which are pending with respect to this human genetics, School of Human Genetics, Tata Safe International and Rajat Kumar Majumdar's case.
But
My lord.
how will you get over the order passed by the CIT appeals for the earlier assessment?
My
year?
lord, may have been those cases were reopened. I had to ascertain,
no.
I will ascertain, my lord, that fact. Kindly grant me, my lord, 1 week's time. I will ascertain from the assessing officer what had happened to those assessment years.
Madam, you know what happened to this 13, 14?
I need to ascertain that, my lord. This is a change brief.
There are 8.1, page 39,
Yes,
Yeah.
last 10 lines.
Yes, my lord.
yes, ma'am.
All right, you both of you verify.
My lord.
We have heard Mr. Amit Sharma, learned senior standing counsel for the appellant, and Ms. Shruti Datta, along with Sakshi Singh, learned advocates appearing for the respondent assessee.
I'm led by my lord, Mr. Pratyush Jhunjhunwala in this matter, my lord.
Where is he?
He is not well, my lord.
He is in Kolkata.
Yes, he's in Calcutta. He's not well,
It
my
is
lord.
Jhunjhunwala, assisted by Shruti Datta and Sakshi Singh. The reopening of the assessment for the year 2014-15 has been set aside by the learned tribunal, among other things, recording that the CITA, within bracket A, for the preceding assessment year, 2013-14, accepted the donation which is also subject matter for the assessment year under consideration 2014-15, and referring to the said decision of the CITA for the year 2013-14, the learned tribunal has allowed the assessee's appeal. The learned senior standing counsel seeks time to verify as to whether any appeal was preferred as against the said order passed by the CITA to the tribunal, or whether any proceedings where any appeal was filed before this court against the order of the tribunal. 2 weeks.
I'm grateful.
You also verify.
Yes, my lord. Yes. I'm grateful.
Delay you condone. 80 days.
Grateful.
Number 4.
My lord, I am appearing for the applicant, my lord.
Yes, Sweta. What is it?
Yes, my lord, I believe, my lord, the service is not complete, my lord, because I think I have made
Mr.
some
Amit Sharma is
mistakes.
here, Prithu Doria is here.
Yes, my lord, if your lordship.
You lost before the tribunal.
Yes, my lord. The issue is that, my lord, the loss before the tribunal, because, my lord, the case was heard on 3rd of February, my lord, that day of Shashwati Puja. The learned advocate representing the appellant was there, sought for an adjournment, and it was not allowed, my lord. And case
Where
was
is the order passed by the tribunal?
my lord, at page 174, my lord, of my stay application. My lord, this is, my lord, disallowance of contribution paid to PF and ESI, my lord, ESIC, my lord. My lord, all these contributions were paid, my lord. But there was a delay of 1 and 2 days only, or maximum 5 days, my lord. And that is why the entire contribution during the period, my lord, financial year 18-19 was disallowed by the learned CITA, and thereafter, my lord, the ITA tribunal also, my lord. They have relied the judgment of Honorable Supreme Court, my lord, Checkmate Associates, my lord. My lord, I believe, my lord, yes, my lord, that is a issue, my lord. My lord, where the difference
No.
is in my case, my lord.
No, in your checkmate is against you.
Yes, my lord, it is against me, my lord. But my lord, in my case, my lord, each and every PF and EHLC contribution, if it is being considered based on the fact, my lord, the contributions were paid. There were delays for 1 and 2 days only, maximum 5 days, my lord. That is why, my lord, I have annexed all the TRN challans, made the payment to the ESIC contribution and PF only. It's a kind of a mercy petition, my lord. This is a small taxpayer and he has never been defaulted, my lord. There was all the even I have relied on the statement, my lord. The statement is at page 83, my lord. This is page 83, my lord. Lord, kindly consider all the payment, due date of the payments, all the payments were made within maximum, there was a delay of 10 days only. But payments were duly made, my lord.
But how will the assessing officer condone the delay? He
My lord,
doesn't
that
have the
is-
power. You have
Yes, my
said
lord.
that there has been a marginal delay and
Yes,
you
my lord.
paid it within the financial year.
Yes, my lord.
But what does checkmate say?
My lord, when there is no payment at all, my lord.
Oh, that's not the
May I-
Sweta, that's not the way you can
My lord,
distinguish a
Yes,
Supreme Court
my lord.
decision.
My lord, that is why, my lord, kindly adjourn this matter, my lord. I shall come back with all the other judgments also, my lord. My lord, because today it's not possible, my lord, for me to present all the cases virtually, my lord. Though I had an instruction for taking an adjournment in this matter, as the assessee
All
wants
right.
to appoint any senior.
Your service is yet to be complete.
Yes, my lord. Service is
All
yet
right.
to be. I have service I have made the service to the ITO, my lord. That's a physical service has already been made, my lord.
All right. They will verify and get information.
My lord.
List the matter next week. By then,
My lord.
service of notice on the respondent department should be completed. And affidavit of
This matter, Hari number 21.
1819. 2020.
Lordship, the matter relates to an addition
Yeah.
in respect of a transaction which I have never entered, Lordship. During the course of hearing also, I have told the assessing officer by way of writing a letter that I have not entered into transaction. I have given my bank statement also. That has been recorded in the order of the learned tribunal, Lordship. The assessment was reopened on the premise that I have entered into a penny script transaction, Lordship. And the reasons which were given, and after that the disposal of the objection, that records that the transaction was that of an immovable property under section 50C, Lordship. So there is a variation, Lordship. And Lordship, to the top of it, the script name is recorded as DLS Export Private Limited. Lordship, in my respectful submission, private limited companies were never allowed the exemption under section 1038. Because the shares of a private limited company can never be transacted across the floor of a stock exchange. That is the prime condition in order to take the benefit of section 1038, Lordship. And that is what the tribunal has considered in the order, Lordship. And during the course of hearing, when I have written the letter that I have not entered the transaction, the assessing officer says that submissions are not acceptable, only 2-line, Lordship. The CIT appeal disposes of my exhaustive submission by saying that submissions are not acceptable.
What happened to the tribunal?
In tribunal has considered my letter that I have and recorded these facts, and thereafter, since I have not entered into the transaction, Lordship, they have given me the relief.
Lord, if your
This is
lordship
the
will
case, Lordship.
But if your lordship will kindly see the assessment order, my lord, starts at page number 9, my lord. Lord, he has dealt with the DLS Exports Private Limited. My lord, if your lordship will kindly straight away kindly come to my lord, page number 10. The case was selected for scrutiny. Assessment is such and such. 147 notice was on the information available system that is engaged in the fund laundering with a motive to earn bogus long-term capital gain with bogus penny stock with DLS Exports Private Limited. According to 148 notice was issued, and thereafter, my lord, this proceedings were initiated. Now, if your lordship will kindly sees, my lord, that my lord, page number, my lord, 13, my lord. My lord, he is responsible. His submissions were considered. After considering, my lord, his submission, my lord, the lordship will fourth paragraph, my lord. In response to the show cause notice, the assessee made the submissions which is perused and considered, and the submissions is not satisfactory. Hence, the same is not tenable and not acceptable. The assessee was asked to furnish the details of the documents repeatedly by issuing the notice under 142(1). In spite of the repeated opportunities, the assessee did not furnish any documents which was asked for by the and the information available in the department that the assessee has done accommodation entry for bogus penny stock in the case of DLS Express Private Limited during assessment financial year 11-12 and earned a bogus long-term capital gain of a turnover rupees 38 lakhs 97,000 in view of that, which is generated from transactions of a bogus penny stock of DLS Exports Private Limited during the financial year 11-12 is not genuine and therefore bogus. Therefore, not it has addition was made. Now, if your lordship will kindly see the CIT's order, CIT starts at page number 15, and if your lordship will kindly see, just a minute. Not CIT's.
What's the
Now, lordship will page number 50. Lordship will kindly see page number 50, paragraph 5. In this case, the addition was made by the assessing officer and of rupees such and such. Grounds of the appellant, the challenge with the assumption of jurisdiction 147 had relied the various decisions. I have gone through the written submission and the laws. Upon the assessing officer has issued a 148 notice on the basis of information received from the department. The appellant has involved in trading in penny stock in DLS Express Private Limited and engaged a long-term capital gain of rupees such and such during the financial year. Hence, on the basis of information of bogus long-term capital gain, the assessing officer issued notice 148, and hence ground number 1 to 8 raised by the appellants are without merit. But the assessing officer on the page of assessment order has clearly cut out the table of information from the investigation being that the perusal of the returns filed by the companies in which the appellants has done share trading are basically non-filters and paper companies. The assessing officers also relied upon the statements of a Devesh Upadhyay, a well-known Kolkata-based entry operator, and the statement of Ashok Kayan and Vikas Surekha and Sri Sunil Kayan, who admitted that the provided accommodation and these statements, his statement, they have admitted that the accommodation entry was in the form of bogus long-term capital gain. In view of the submissions before me, the appellant has not challenged the contention of the assessing officer and has not challenged the statement of the entry operators, which the assessing officer has made the addition. No attempt has been made to explain the nature of the business and the actual work done by the various companies whose shares the appellants has traded. In the context, the contentions of the Swati Bajaj was discussed and it was done. So, the statements were in their statements they have stated. No, these three people have stated that they are engaged in the and their statement was never controlled. Yes.
See, the reasons for reopening was bogus penny script.
Yes.
While disposing of his objection,
yes,
you referred to some sale of immovable property as LTCG claim. Two different, that's one of their grounds. And one thing, if you see, 38 pages, CIT appeals order.
Yes.
36 pages or 35.5 pages, he has extracted their submission,
yes,
their grounds, their oral written submissions.
yes. On decision.
Nothing, they have not dealt with his specific plea. Let us leave all the other grounds. You come to page 18.
18.
8.
Yes.
Ground number 11.
Further, they had ordered adding such and such on bogus long-term capital gain when admittedly.
No, ground 11.
Page 18.
Page 18, inner page 4.
Yes.
11. For that, the learned AO
ordered in adding. Yes, adding of rupees 38 lakhs 97,000 on as bogus long-term capital gain when admittedly all the evidences and documents were filed to prove the assessee did not involve in the alleged transactions, and the assessing officer failed to bring any evidence on record to prove that the finding based on which the additions were made. But this is the ground.
Now you come to page 50, para 5.1. What is this finding? What is the material he had to say that they engaged in this transaction? That's what the tribunal says.
Yes.
Tribunal has quoted their letter dated 21/12/2019, saying that submit that for the no shares has been sold by the assessee. Copy of the bank statement has been annexed.
But my lord, the subject to correction, my lord, the statements of those entry operators were, my lord, that is there, my lord.
And one more thing, if you come to page 55, para 8.
Right, yes.
This is the pleading of the assessee.
Yes.
Filed their objection to the notice under 148, wherein it's very strange to point out the assessment was reopened, alleged ground of appellant earning LTCG on sale of penny stock. While in the disposal of, the reasons shows, reasons for reopening was capital gain on sale of immovable property under 50C. This clearly shows that the entire proceedings were conducted in a cavalier manner without application of mind and looking into the facts. In response to the notice dated 142, show cause so-and-so, appellant again submitted on 21/12 that no shares were sold. You should bring something on record.
Yes, ma'am.
This appeal by the revenue under section 260 capital A of the Income Tax Act 1961, within bracket the act is directed against order dated April 8, 2024, passed by the Income Tax Appellate Tribunal A Bench Kolkata, within bracket tribunal, in ITA number 143/KOL/2024 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. Page number 4, question A and B alone, sir. We have heard so and so. The short question that falls for consideration is whether the reopening of the assessment was validly done. In the reasons for reopening, the assessing officer alleged that that the assessee earned long-term capital gains, within bracket LTCG, of rupees 38,97,080 on the sale of penny stock of DLS Export Private Limited. The assessee in their reply to assessee in their objections to the reopening stated that during the assessment year under consideration, no shares have been sold by the assessee. Copy of the bank statement was also attached to the said letter dated 21/12/2019. The assessee therefore prayed for dropping the reassessment. The objections were disposed of by the assessing officer on a totally different ground, stating that the reopening was on account of capital gain on sale of immovable property under section 50 capital C of the Act. This will clearly show that the assessing officer did not apply his mind and did not take an independent decision to be valid in independent decision in the matter. Therefore, the reopening proceedings has to be set aside and rightly set aside by the learned tribunal. That apart, the assessee took a specific stand in writing in response to the show cause notice dated 20/12/2019 by submitting a reply on 21/12/2019 stating that no shares were sold by the assessee during the period under review and submitted bank account statement in connection with the same to prove the authenticity of its submission. This specific ground raised was brushed aside by the assessing officer, and the assessment was reopened and additions were made. The same grounds were canvassed before the appellate authority, namely NFAC. At the first blush, it appears that the appellate authority's order is a well-reasoned and detailed order. But on a closer scrutiny, we find what the appellate authority has done is to extract the entire grounds of appeal and the submissions made by the assessee, which covers almost 36 pages of the 38-page order. And the decision is only in paragraph 5, wherein the appellate authority has not dealt with the factual issue at all, except for referring to the decision of this court in the case of PCIT versus Swati Bajaj, dated 14 June 2022. Thus, the order passed by the appellate authority is also an outcome of total non-application of mind and requires to be set aside, which was rightly done by the learned tribunal. Thus, the conclusion of the learned tribunal that the assessing officer has reopened the assessment on an erroneous formation of belief and he made addition without any specific details possessed by them is fully justified. Thus, we find no grounds to interfere with the order passed by the learned tribunal. Accordingly, the appeal fails dismissed and the substantial
Grateful.
questions of law are answered against the rebel.
Grateful.
Grateful.
Your Lordship.
Yes.
number 36 and 37.
What I'm appearing. But I'm really grateful to my senior friend. He has prepared a chart.
Several questions.
Several
also I
questions.
got request to prepare.
It's because he's a big assessee, so that there
Yes,
will be a lot of
yes.
questions.
Now, my lord, if your lordship will kindly see, my lord.
First,
First,
disallowance and
yes. Now,
40A.
yes. Now, if you, my lord, if your lordship will kindly see assessment order, page number 23 to 34, minutes, assessing officer observation, page number 23. Now, my lord, yes. Paragraph number 13, my lord, disallowance under section 40A. During the course of assessment, the assessee was required to furnish the details of payments made to the foreign parties along with the details of TDS deductions on the same. On perusal of the statement furnished by the assessee, I find that the assessee had paid a aggregate sum of rupees 7 crore 28 lakhs such and such to the various foreign commissions agents towards procurement and marketing export orders. However, the TDS has not been deducted. No TDS has been deducted under section 195 on such payment, and therefore the same is liable to be disallowed. It would be pertinent to explain that the legislative history behind the taxability of such export commissions. The apex court in the case CIT versus Tosuko Limited, such and such, held that the commission due to foreign agents were not liable taxable since the non-resident assessee rendered the services abroad and did not carry on any business operation in India, and the amount earned by them cannot be said to be accrue or deemed to accrue India. In CBT subsequently came up with a circular number such and such, wherein it has been made clear that the commission paid to foreign agents paid to exporters are not taxable in India. CBDT by its circular number 7 dated such and such has withdrawn its earlier circular number 23 dated 3rd July 2009 163 such and such and dated 7/2/2000, meaning thereby from the financial and 9/10 the payments have now become taxable and the assessee is liable to deduct tax on such payments. The attention was invited to recent decision of SKF Boilers Private Limited, wherein it has been held that the commission payable to foreign agents is deemed to accrue and arise in India and is taxable under the Act in view of the specific provision of section 5(2)(b) read with section 9(1)(1)(i). Hence, The provisions of section 195 would apply in view of the foregoing decision. The export commission of rupees 7 crore such and such is disallowed and added back to the total income. Now, if your lordship will kindly see 5(2)(b) or 9. My lord, this is the findings of my lord, assessing officer, and my lord, in this my lord, CIT appeals finding is my lord, at page number 67. My lord, ground number 9. So, my lord, the assessing officer has relied on the provision of section 5(2)(b) and my lord, section 9(1) Roman 2, my lord, has said that my lord, TDS has to be deducted in section 195. And also, my lord, by recent circular which has override subsequent circular, my lord, and also, my lord, in view of judgment of SK boilers. So, and my lord, CIT appeal also, my lord, confirmed his submissions are recorded, my lord, and after that, my lord, CIT is finding, my lord, that is page number 72, my lord. It says that I have considered the submission of the authorized representative of the appellant as well as the assessment order framed in the light of the materials available in record before the assessing officer during the assessment proceedings. The assessing officer, while making the additions, has considered the circulars issued by the board and also placed the reliance of the decision of SK Boilers Private Limited. I agree with the view taken by accordingly. The A was upheld and the ground was dismissed. The appeal is dismissed. Now, if your lordship will kindly see the judgment of SK Boilers. I'm relying on the judgment. So sorry, I have only 2 copies. Not if you. The judgment of SK Boilers. And my lord, tribunal's finding is page number 102. My lord. Tribunal paragraph number 7. Facts of the case is that the assessing officer, upon perusal of the details payments made to the foreign parties, has furnished by the assessee, observed that the assessee has made aggregate payments of rupees 7 crores on various parties, and the pronouncements and the marketing of export orders. They noted that the assessee has not deducted TDS at the source of maintained 195. Therefore, the same were not allowable in terms of the provision of section 40 IA. The assessee has entered with an agreement with the non-resident agents of selling the products outside the India, and the commissions were recorded. The services entirely outside the India, and the part of the services were never rendered in India, and the nature of the services performed by the commission agents were not confined to the sale agents related to the franchise and marketing promotions, the product of the SSE, etc. It is also
Totally 9 questions.
Yes, there are total 9 questions. I'm not. This is the judgment which was relied by the
advanced ruling.
Yes. Yes, advanced ruling. Yes. No, my lord, thereafter, my lord, it was deleted, my lord. This was the, my lord, his. But then, my lord, it is stated, my lord, that as per the CBDT, the payment on account of export commission would be taxable, and hence the SSE is liable to deduct tax at the source of under section 195. The assessing officer relied upon the decision of advanced ruling. That, my lord, then CIT's observations that recorded, my lord. Thereafter, my lord, the authorized representatives' submissions were also recorded, and after recording that, and after recording the submissions of the DR, my lord, Subsequently, my lord, page number 106, if your lordship will kindly see, we have heard the rival contention and peruse the material record. We find that the commission was paid to the foreign agents with whom the SSE has entered into agreements to render services abroad, and no part of the services was ever rendered in India. We also note that those are the non-residential companies, the commission agents, who operated in foreign markets and provided their services there only. We have also perused the provisions of section 185 of that, and the impugned sections provide that for making the payments for a sum of chargeable to tax in India and to a non-resident not being a company or to a foreign company, in the presence case, the commissions in the hands of the foreign agents are not taxable or are not liable to tax in India, and the same is paid in India in respect to the services rendered abroad and non-residents commission agents. The case of the SSE finds support in the case of Apex Code, in the case of GE India Trading Technology such and such Supra, wherein the Honorable Court has held that if a sum payable to a non-resident is not chargeable to tax in India, the payer is not liable to deduct tax at source as per section 195 of the Act at the time of making the payment of. Therefore, there is no question of invoking the provisions under section 40IA. We further peruse the provision of section 9(1), which deals with the income accruing or arising through and from business from any business in connection with connection in India, which shall be deemed to be accrue in India. Further, the explanation
No, we'll go one by one.
My lord.
First is the disallowance under 40 AI.
Yes.
The tribunal was of the view this advanced ruling authorities.
Yes.
This, what is it? SKF
Yes.
boilers.
Yes.
But SKF boilers has not taken note of that 1980 judgment.
Yes, it has not taken note.
Toshoko.
But yes, but I was noted on this that the question itself, which has been formulated before my lords, questions the order of the tribunal on very limited grounds. Can you see the frame of the question? Can you see the frame of the question? The question, they have raised a different controversy, which is not there in the record. Can you see the question at page 5? Remember, in the stay application. They're not raising any legal issue in the question. That is what I was trying to submit. This ground of challenge, this is not borne out from the record. The assessing officer did not disallow on any such ground. Whereas if my lord sees the assessment order, he was on the basis that the circular had been withdrawn. But the question which they have formulated before my lords are as if some kind of verification was not done or I had not produced evidence. They have not put that legal issue before my lords. Therefore, that question as framed is misconceived because it does not arise in that sense at all.
So his finding is only because the CBDT circular was withdrawn.
Not for this. So this
CBDT may withdraw its circular, but if the act has been amended, then probably you can say that this can.
As far as the legal part is concerned, the act was not amended. The circulars were in the assessee's favor. The board withdrew the circular, and that advanced ruling did not take into account that explanation to section 9(1)(I), that even if it is to be taxed, it is only to the extent of the operations here. So if there are no operations at all, then there is no taxation. And what Toshuku was again that if there is no activity in India, then there is no taxation in
because
India.
it is not the revenue state that there was some semblance of activity within India.
Therefore, this question as formulated in my submission does not arise. This was not the basis of disallowance at all.
And what is this Andaman seafood?
But Andaman seafood was on a very different set of facts. It was not even cited.
It was not cited.
No, because this was a case of 917. the technical consultancy in regard to foreign exchange derivative transactions. So there, that explanation 1 does not apply for this. At page 5, my lord will find the question which was considered by our court.
This is 917.
Yes, and then that explanation is not relevant for 917. The explanation under 919.
Income Tax Act.
Lordship.
Punjab. Income Tax Act.
So 91I, my lord, and then the explanation 1, clause A.
Only such part of the income as is
Right.
or arrives in India shall be only such part of source. So, and is reasonably attributable to the operations carried out in it.
Therefore, even if one takes it as covered under 91I, the explanation says only that part. So when there's nothing here, and that is the basis on which the tribunal decides matter.
A and B.
A and B, yes.
Never cited.
No, and no, it is on different facts. If my lords are pleased to see the question, page 5.
The grounds are different.
Yes. There also the DTA interpretation was involved.
But question number C, my lord, next question. On page number 14 of the assessment. Market to market loss, forward contracts. On perusal of the notes of the accounts and the details filed by the SSC, it is noted that the SSC has booked market to market exchange loss of rupees 99.96 lakhs on the open forward contracts. The aforesaid loss is notional and contingent in nature, and therefore they cannot be claimed as a deduction from profits of the business. Reliance is placed by CBDT's instruction number 3 of 10, dated 28/9/2010, which is as follows: a large number of SSC are said to be reporting such losses on the market to market basis, either suo motu or in compliance with the accounting standards or the advisory circular issued by the Institute of Chartered Accountants. The issue whether such losses on account of the forex determinations can be allowed against the taxable income of the SSC has been considered by the board.
This is not a question of law.
As formulated, no, it's not. As formulated, it's not a question. Otherwise, it is on principle, it is covered by judgment of
By that price water.
Yes.
Price.
The question is at page 3, and my lord's observation at page 4, the second last line.
Now consider.
It should be positive direction, not possible direction. Then question D.
Well, the question D is, my lord, the liquidated damages of rupees such and such received from the suppliers in compensation for the delivery of installation. That is my page number 27 of the assessment order. My lordship. Page number 27.
This is covered by this Saurashtra case.
Lordship, when the question is formulated, it is not on a factual aspect note, which is never in controversy. Kindly see, without examining the nature, specific terms and conditions of each of the contracts. He took the view that it is a revenue receipt. So this is not the ground on which the disallowance was made. But this is the Supreme Court judgment.
If the assessing officer doesn't call for all the contracts, how the assessee can be blamed for that?
But page 427, if my lords are pleased to have paragraph 13.
Paragraph 13.
My lord.
Yes.
The AO held it was a revenue receipt.
Yes.
Yes.
Then question E.
The question E.
14-year rule 80.
Yes.
But here again, with the question as formulated, it's only on interest. The 21 crores is not interest entirely. It is only, the interest element was only 9 crores 61 lakhs. So the question is under Rule 82 II, which is the rule for interest. They have, this entire question is on interest, not on the other part of the expense. The disallowance can be of interest, and then 0.5% of the opening and closing investments, average of the opening and closing. So on that part, they have.
But you succeeded before the commissioner.
I succeeded before the commissioner on the interest part.
Yes, interest.
Because he found that I had net interest income. So he said that because the net interest income was taken as the expenditure by the assessing officer by mistake.
And this South Indian Bank decision.
As far as interest is concerned, that if they are mixed funds, and I have a copy of that.
The CIT observation on page 83, 84.
And here in the assessee's own case, for 2009-10, it was accepted. So far as expenditure incurred relating to investments capable of yielding income.
My lords, referring to my lords have found that
Page 5 of your statement.
my lords.
So, page 5, para 5.
No, this was the decision cited of Ultratech Cement.
Ultratech. So if he had a reasonable explanation for that, you cannot invoke Rule 80.
Yes,
That was one line of decision.
Yes, but that note here the assessing officer said that you have not maintained separate details in account.
But mixed funds can be there.
Lordship. And what can you have a look at the judgment in South Indian Bank? But there are 5 paragraphs, 16, 17, 20, 27 and 28. 16, 17, 20, 27 and 28, page 8. 8, 9, 13, 14.
In fact, we followed the South Indian Bank in one matter, sitting in courtroom number 16.
It would have just come then.
John. Stapler. Then next question. Advance to farmers.
But here again, the question is formulated,
Page 7.
proceeds on the basis as if it was a case of provision and not a write-off. Again,
It's actually a fact, not a question of law.
it was actually written off. It was the assessing officer notes it's written off. He says it's not in the course of. He says that since it's
So it is allowable under 37(1).
Yes.
Then G.
G is
Interest paid to and received from the same party. Both transactions should be taken together and the amount of interest paid by the assessee should be allowed to be set off. They followed Bank of America. That order has become final.
Yes, but I didn't find anything further on this one. In fact, it is not even reported. It's paragraph 3, 4 and 5.
So here also the interest paid and received were from the same party.
Income tax department, but basically the interest on the demand and interest on refund.
All right.
Department, of course, says that the interest expenditure is not allowable, but the peculiar situation is that it's the same party.
Then H.
Fresh claim of employee stock option, my lord, and ESOP. So, my lord, but ITAT's observation is page 116-17. Paragraph 29, 28 to 29, yes. The facts are that the SSC has implemented the employee stock option plan in accordance with the Securities and Exchange Board of India. In such, SEBI and the employees of the SSC company were granted stock options under the same scheme. An excess price, which was the market price, as has been done, and the gain was again the stock option. Then taking during the year, the SSC has declared a sum of rupees 314 crores as employees' compensation cost accruing for the year based on the vesting period of the LOSPs, and it was duly disclosed in the annual accounts of the for the said year. The SSC claims to be entitled to the deduction in respect of the amount. Since the issue is raised at the first time before the tribunal, the issue has not been examined by the authorities below. After hearing the contention and the perusal material file, we find that the same issue has been decided. Coordinate bench in SSC's own case for the assessment year 9-10. The operative part is as follows. Assessment year 9-10. Considering the decision of the coordinate bench, and the issue is admittedly and undoubtedly allowable, and the SSC has restored the same for the addition of the assessing officer during the verification, and the same is decided in the same by relying of the decision about the assessment year 9-10. This is the one quiz. Accordingly, this was allowed. This question was raised for the first time, and since it's the earlier assessment year, it has been in favor of the SSC by the tribunal. That's
for this ground H.
Yes.
What happened? Initially, the law was not settled.
Yes, no, the tribunal was taking divergent views. So thereafter, when there seemed to be some, a special bench was constituted. Special bench held, considered everything, and held that it's not a contingent liability.
So initially, no deduction was claimed.
No, in the accounts there was a disclosure that this is the amount. So it is a fact on record, but no deduction was claimed. Thereafter, when the matter reached the tribunal, by that time, there's some certainty because the special bench decision had come, and there were other bench decisions following that. So then, the additional ground was filed for the first time in assessment year 9-10. So the tribunal in that year said that in principle they said assessee is entitled to it, but the facts and figures they can look into, and it was sent back. So in this year,
and what happened after it was sent back?
There is controversy raised by the assessing officer, which again traveled up. It's now pending before the tribunal. Now, in this year, the tribunal, number 9-10, the department has preferred an appeal before my lords, but that question has not been raised on the remand. This year, the tribunal has followed its earlier order, again saying that it was in the accounts, the figure was in the accounts, but in principle, the assessee is entitled, but it should be looked into the facts.
So in this 2 years also, they have sent it back.
They've sent it back. That's all that they have done. So they say that they're referring to a Supreme Court judgment in the question. Again, this was not cited, but I have copies of that.
So restore the same to the AO for due verification of the facts.
Yes.
And for 9-10, if they have not preferred an appeal.
Yes, this is that judgment which is referred to in the question, which they formulated before my lords. This was a case, the revised return was filed out of time. And so in that revised return, the claim was made. And the tribunal directed the assessing officer to look at the revised return, which was out of time. So the tribunal by itself did not decide the question. So in paragraph 8, the court was pleased to distinguish the earlier decisions and hold that
In paragraph 7, 135 was quoted on there.
So this was a case of a revised return filed beyond time.
yes. So the claim was made in that return. So tribunal did not decide the claim. Tribunal said the assessing officer will decide it. So the court said the tribunal has not acted under section 254. The tribunal could have decided it as a ground by itself. But in our case, there is a decision on the ground.
But the tribunal, I'm sorry, in this case, Supreme Court says assessing officer had no jurisdiction to consider the claim. So therefore, that was also another ground to allow reject the assessee's plea.
Yes. Because the appellate authorities are empowered to entertain additional grounds.
But here it is only a case of a remand.
I know. And after deciding in principle.
Principle. Okay.
It's not that the claim has not been adjudicated. It has, in law, it is adjudicated because there's special bench decision. But the quantification norm the officer needs to see. But page 117 after the quotation.
We admit the issue.
And then
which is admittedly and undoubtedly allowable to the assessee and restore the same. So they decide and for computation probably is sent. But in 910, despite this allowing this question, the AO took a different stand.
Yes, that I've had the advantage of looking at it, but it is before the tribunal. So I don't think that will really weigh at all. But that's a matter in the AO's hands, because here also it's gone back. He may again disallow.
So it's not a question of law. Then last is
Patent
registration charges.
Yes. So the assessing officers, page number 17.
It is they relied on Finlay Mills.
Yes.
And the Dalmia Jain.
That's page 478. 8 lines from the bottom, 9 lines from the bottom. By registration, the owner is absolved. By registration, the owner is absolved from the obligation to prove his ownership. It is treated as prima facie proved on production of the registration certificate. It is thus merely saves him the trouble of leading evidence in the event of a suit in a court of law to prove his title to the trademark. It has been held that registration is in the nature of collateral security furnishing the trader with a cheaper and more direct remedy against infringers. Cancel the registration and he has still his right enforceable at common law to restrain the piracy of his trademark. In our opinion, this is neither such an asset nor an advantage so as to make payment for its registration a capital expenditure.
Then this was followed in Dalmia Jain.
Dalmia is on the aspect that where expenses are incurred to protect the existing trademark, legal expenses, then those are revenue expenditure.
Slightly different.
In our case, there are both new and old trademarks. So both types of expenditure were involved. But here at page 757 in Dalmia, the second new paragraph.
It is only an expenditure for protecting their mark.
The,
So that they need not go for multiple forums to prove. Sir, please come. Now there are two appeals.
Two appeals.
in the second appeal,
There are some additional.
there's one extra question note on that. I found out that the matter is pending before the Honorable Supreme Court, but the other questions not would be covered by.
So first we'll finish this. IT 89 of 2025. Please be seated. This appeal has been preferred by the Revenue under Section 260 Capital A of the Income Tax Act 1961, within bracket the Act, against the order dated May 10, 2024, passed by the Income Tax Appellate Tribunal, C Bench Kolkata, within bracket Tribunal, in ITA number 1068/KOL/2017. Now there are two appeal numbers given. Both are for 1011.
My lords, I'll just.
Yes.
One by the SSC, one by the Revenue before the trial.
In ITA number 1068/KOL/2017 and ITA 1222/KOL of 2017, both relating to the assessment year 2011-1011. Two appeals had been filed before the learned tribunal, one by the assessee and the other by the Revenue, which have been disposed of by a common order, impugned in this appeal. The Revenue has raised the following substantial questions of law for consideration. Sir, page 5, 6, 7, 8, A to J, A to I. Shall I? If you can give a soft copy of the grounds.
Of the grounds,
No, you have to give.
So,
Can you give a soft copy of your substantial questions of law?
Soft copy, my lord, right now.
Oh, e-filing has been done?
Yes.
Then, because reproducing it takes a lot of
Yes.
time. We have heard so and so. We have elaborately heard the so and so, and carefully when the materials placed on it. We propose to decide substantial questions of law. Substantial question of law are dealt together. That the tribunal was not justified in holding that the foreign payment amounted to 7.07,989 had been made on account of export commission, inasmuch as such conclusion had been reached without ascertaining the true nature and the purpose of the foreign payment. Without appreciating payments were not supported by any evidence, including evidence of services, tax residency certificate, PE declaration, capital P, capital E, etc. The Revenue further contends that the learned tribunal ought to have taken note of the decision in the case of creating income United This is contention was. Yeah. Okay. Then that's right. Okay. No, they will be the 19 the counter is limited to 30. That commission which was paid. That export commission paid to non-residents for services rendered abroad without carrying out any business operations in India that was not taxable. As could be seen from the assessment order. The assessing officer held against the assessing of the ground that the previous CPD circulars, which were whichever of the assessings were withdrawn by circular number 7/2009, dated October 20. Therefore, the assessing officer that export commission payments have become taxable from the financial year 2009. In support of this conclusion, the reference was made to the decision of the Authority for Advance Ruling income tax in the case of SKF Boilers and Dryers Private Limited, 2020 343 idea 385 within bracket all contractors. It is not in dispute that the decision of the Honorable Supreme Court should hold the fee. Was taken note of it was not in dispute that non-resident commission interest active and the entire services that provided not to the effect of the before the tribunal rightly know that can have in the light of certificate there is a line and explanation one to the section. It provided that and such part of it as was recently to the operations carried out. In the case of inputs some of the same is distributionable and not applicable facts of the reception because it's rendered in respect of a payment for expert guidance and consultancy in respect of in foreign exchange derivative transactions to which section 9 bracket 1 bracket small 7 was applicable and the applicability of the double taxation avoidance given this aspect is evident from perusing the decision of the division bench in the case of Andaman Seafoods Private Limited. More particularly, substantial question of law legal which related to Forex derivative transactions, whether it is chargeable to tax in India under section 9 bracket 1. Therefore, the tribunal rightly distinguished between said decision. This is the decision. Therefore, question of law and evidence are also against the it's not suppression pertains to availability of market. Loss of rupees 9.6 lakh forward. This we note that this issue is squarely covered in the light of the decision of this court in Principal Commission of Income Tax 1 from Kolkata versus Rice Waterhouse School Books Private Limited. The court took into consideration the CBDT circular dated 23 and held that it is not possible for the board to give any direction to the assessing officer, as the board under law cannot issue any positive direction, as the settled legal principle is that the assessing officer is an independent authority and none can dictate to him as to how and in what manner he is to complete the assessment. Further, it was held that conscious of this legal position, the board in the instructions dated 23/2010 has stated that the assessing officer may follow the guidelines given in the instruction, which is also one more indication to say the assessing officer is not bound over by the instruction given by the board. That apart, the CBDT instruction cannot override the decision of the Honorable Supreme Court. Therefore, question number C is answered against the next question of law, namely question of law D pertains to liquidate the assets of the received from suppliers as compensation for the installed / complete construction of a capital asset within the stipulated time. On this issue, the assessing officer was of the view that such liquidated damages were in the nature of regular income, and further, the assessee had not adjusted the amount against block of capital assets. The Commissioner of Income Tax Legal Faculty agreed with the assessing officer. When the matter traveled up to the tribunal, some of the tribunal have been right to note of the decision of the Honorable Supreme Court. The Commissioner of Income Tax was Saurashtra Cement Limited, 2010 5/25 practice.
Por 21 hold on. रेडी में आचे खाओ
We felt that the delay of suppliers resulted in the profit and the suppliers that capital not received in the and that the liquidity that ought to be from the cost of the private reflects the correct but it's the foundation of the lost sight of the fact that the sum of the was actually compared to the or the assessing's net income greater than its interest expenditure. While the assessing challenge is the largest investment in tax-free security. Further, I think the topic disallowance and yearning of excess income had not been restored. For the investment made with assessing bonds and shares, which is interest in bonds, some of them could be couple of such exposure and and accepted the same in the line of the decision of the what do you think? Disallowance and supplementary question of law. Question. What if that advances were to the profit and loss of it and cannot be claimed as deduction upon right was required that was claimed, but black X was claimed, but not set off. Direct tax within the tax right from the capital and if income tax appeal number 1 double sum of 2012 dated 7th July while affirming the bill taken by the land exemption, it was held that their interest was paid to the paid and received from the same party. Even bracket the question is primarily from the income tax department. Bracket close. Both transactions should be taken together and the amount of interest paid should be allowed to support against the interest paid to the department and tax holder and subsidies. Therefore, the does not call for Freedom Investments versus Commissioner of Income Tax, 2024, 67 taxable of 139 This decision cannot apply to the taxes of as the Supreme Court has been where the tribunal power to keep 54 of them to consider to give common instead I directed the assessor officer to consider the appellant's claim. Then the assessor officer had no jurisdiction to consider it made by the assessor in the reverse return filed after the time prescribed under section 139 for filing the returns had already expired. Therefore, the decision of Sria was be of no assistance in the case of the next Couple of law suggested with regard to the fresh claim of stock option plan. Within bracket is bracket which was released for the first time before that this issue fine. The order find reasons to question the issue before the law and also observe the claim made is admittedly and undoubtedly allowed to the assessor and restore the same to the adjudication before the assessing officer after doing verification of the facts and decide the same. But there is no question of law that's a substantial question which arises on the section. The last substantial question suggested is paid registration charges. The judge cannot dispute the fact that this issue is merely the Honorable Supreme Court as a claim. Another decision on in favor of the assessee on the same issue is the case of that. Volume 7. That's the time. For the purpose of protecting the all the point here, the very questions of law, not substantial questions. Yeah. What about the next matter?
So next matter, I think question number 6, my lord. Roman 6, my lord, that is, my lord, pending before the Supreme Court, so my lord, your lordship can admit. So,
Why don't you take the vote?
no,
Yes,
this-
other question?
But I have
Yes,
tabulated
yes,
minutes.
my lord.
Carbon credit,
Yes, my lord.
that is pending before Supreme.
Yes, but
Yes,
that I found it in the reports. Where it is from.
Lordship can admit this.
The High Court decision you have got, M plus.
Look, there is one, just, can you take page 2, look, it is there. Look.
We have to admit that question.
There's no, that it is pending, that
Yes, your lordship.
The notice has been ordered. There's no stay or anything.
No, your lordship can admit.
as such it is covered by the High Court judgment. There's also not, the tribunal has also referred to not the Andhra Pradesh High Court, my home power, which was also considered not in, and this Karnataka High Court, both are considered by the Madras High Court.
So it's pending, my lordship.
In fact, my lord sitting in Chennai, Madras High Court had decided this point. Same.
That is the other decision, I think.
I think the SP is spinning perhaps.
Ambika Cotton.
I'll just check. But I think I had seen that.
you have said own case for 910.
But that they've raised the question there. They've raised the question.
Now that appeal is pending before.
Yes, no, it has not yet come up for admission.
One thing. All other questions we say it is covered with the decision in the earlier case. Huh?
Yes.
And
And
so far as question number 4 is concerned.
No, 6, my lord.
6.
Yes.
6 is concerned. What is the appeal number for 910? You don't have the appeal number.
No, the issue is there, but I have the appeal.
Appeal filed by the
13 of 2020.
Appeal number नहीं दिया बस. Appeal नहीं.
revenue
See.
One, two. Substantially proceeds 1, 2, 3, 4, 5.
But 28 to 13 of
We covered the definition of get a 21 7 25 even bracket should commission of income tax from 1 Kolkata versus ITC. According to the substantial regard to substantial question of law number 6 is concerned, the learned tribunal followed the assessor's own 2009 and also the decisions of the High Court of Andhra Pradesh, High Court of Judicature, High Court of Karnataka, and granted relief to the assessor. The question being whether the receipt from sale of carbon credit was a capital receipt and hence not liable. So far as the assessor's own case for the assessment year 2009-10 concerned, the revenue has preferred ITA number.
ITL.
Well, ITA 83rd, it's ITA 51 of 2020.
Admitted.
No, only the delay was condoned.
ITA number 51 of
2020.
and the delay in filing this in the appeal has been condoned and the appeal is pending. This appeal along with it after 2 weeks. But you have verified the status of this still it is.
I just checked, no, it's still pending.
For substantial question of law, all other
Hello.
I'm great.
Wait.
you have to had work for the whole day. You'll see
Appellate side, daily list, serial number 1.
Your Lordship, I'm praying for a very short passover of 2 to 3 minutes, Your Lordship. I inform him he's in court number 5. The other side is also prepared.
Who's for the respondent?
Mr. Siddiqui, Your Lordship, and Mr. Sanyal.
All right.
Grateful to Your Lordship.
Serial number 2.
I beg to appear on behalf of the alleged contemners, and we would like to use an affidavit.
Order has not been completed.
No, to be very honest, my clients has preferred an SLP to that extent.
Oh.
So I would like to, there is two things was troubling me, Initially, Lordship has strike down the order of the single bench because of the ground of the natural justice. And subsequently it was found the person concerned did not have the adequate qualifications. The qualification is not recognized by
that we have considered.
Right. After that, we have considered the same. We wrote the email to the concerned department, but the answers came in the negative. So, we would like to bring in the record.
But how they can sit in judgment over our decision?
Sorry,
No. Either you can file an appeal against this.
I have done it,
In
That
Supreme Court.
In Supreme Court, I'm sorry,
But no. That SLP number you will give.
The ID number is here, I
You
can
give it in that affidavit.
I would like to, yes.
The learned advocate appearing for the respondent / alleged contemptor submitted that the alleged contemptor may be permitted to file an affidavit as the state has preferred an appeal before the Honorable Supreme Court against the judgment dated 5/5/2025. Let such affidavit be filed within a week from date. 1 week is sufficient. 1 week is sufficient.
But kindly give me 2 weeks.
2 weeks.
2 weeks.
2 weeks from date. Let an advance copy be served on the learned advocate appearing for the applicant.
But
Give a date after 2 weeks.
Number 3.
grateful to your Lordship.
I am the petitioner. Lordship, order was passed on 10th April 2025. Lordship, order was not complied by the concerned respondent.
Coming up for the first time.
First time, Lordship.
Let notice be served on the alleged contemptor. In addition, the learned advocate appearing for the applicant shall serve the learned government counsel. And who's the alleged contemptor?
DLR Domjur.
On the learned government counsel appearing for the respondent / alleged contemptor. List the matter after 1 week. Within a week, you serve notice.
Lordship.
Next.
Serial number 4 and 5.
Somebody is waiting, no? No. Morning session, one advocate was waiting. No?
That person.
All right. List next week.
Serial number 6.
Lordship, I appear on behalf of the respondents in this matter, but the appellants are not here. This is a matter where they have claimed for compensation, additional compensation under the Petroleum and Minerals Act. Lordship.
We will say not today.
Lordship, next week if it...
Tomorrow probably you'll let him appear. Huh? Not today.
Grateful, Lordship.
Serial number 7.
This is that Juma Sen appeared. Not today.
Serial number 8. Passover matter, serial number 1.
This matter has come at my instance. Lordship, this was regarding the jurisdiction of the Bureau of Investigation to issue show cause and adjudicate also. Now, Lordship, what a development has happened that the learned single judge in the similar circumstances now has admitted the writ. In my case, it was dismissed on account of alternate remedy. On the similar powers of the DRI, there are two investigation wings, Lordships, of the state. One is the DRI and one is the Bureau of Investigation. The same pleadings are there in both the situations. Because the person who is investigating, as per our submissions, he cannot adjudicate because there are no proper officer notifications. What I discussed with my learned senior also, Siddiqui sir, that if this matter, because the learned single bench is seized, I was dismissed on account of alternate remedy only.
So what we can do is set aside this order, restore the writ petition, tag it along with that.
That is the
and same protection we can say. You give a reply to the show cause.
Lordship, in my case, now what the development has happened, because I didn't had any stay. So they have passed an adjudication order. I preferred an appeal after paying 10% fee deposit, which is more than 1 crore. Now, appellate authority dismissed my appeal on the ground of delay. And to that extent, my writ is pending on delay before the learned single bench.
That also will be clubbed.
That also will be clubbed. And I've already paid 1 crore, Lordships.
All right.
I don't want a refund, but it's a free deposit.
This intra-court appeal by the writ petitioner is directed against the order dated 1/2/2024 in WPA 1092 of 2024. The writ petition was dismissed on the ground that the order impugned in the writ petition is an appealable order and that the appellant should not bypass the appellate remedy. It is submitted by the learned advocate appearing for the appellant that identical issue, namely the jurisdiction of the Bureau of Investigation, has been raised in another writ petition in WPO 819 of 2025 in Polami Ghoshal versus Assistant Commissioner of Revenue, Directorate of Revenue Intelligence and Enforcement and others. And the said writ petition has been admitted on 1/10/2024 to decide the jurisdictional issue, and an interim protection has also been granted. Since the learned single bench has assigned reasons as to why the writ petition should be entertained, to namely to decide the jurisdictional issue, we are of the view that the present writ petition, the writ petition filed by the appellant herein should also be heard along with the said writ petition, since the court has prima facie satisfied that the jurisdiction point has to be considered and admitted the writ petition. So far as the interim protection is concerned, there is no scope of passing any interim order in this appeal, since during the pendency of the appeal, the authority, namely the Bureau of Investigation, has passed an adjudication order, as against which statutory appeal was filed upon effecting pre-deposit of 10% of the disputed tax. But however, the said appeal was dismissed by the appellate authority on the ground of limitation, which the appellant has challenged by filing a writ petition in WPO PA number so.
I'll just give the number.
So and so, and the same is also pending. Therefore, the said writ petition also should be heard along with WPA 1092 of 2024. Accordingly, the appeal is allowed, the order impugned is set aside, and the writ petition is restored to the file of the learned single bench to be heard along with WPO 819 of 2024. The other writ petition filed by the appellant in WPA number so and so shall also be heard along with the aforementioned two writ petitions.
WPA 13354 of 25.
13354 of 2025.
Lordship, in that WPA, there is an issue on merits also. It's a classification issue. So, Lordship, I think on the classification issue, let it be heard by the Commissioner Appeal, because he has...
That order you take from the single bench.
Lordship kindly does not tag this one, the new one, because that is only on merits. Because jurisdiction issue.
No, your appeal was dismissed on the ground of delay.
Delay. So that...
Suppose that order is set aside, then automatically matter will go to the Commissioner.
To the Commissioner Appeal for decision on merits only. If this is tagged, then it will go for hearing. Now, actually, learned single bench, all these delay matters, learned single bench is taking.
The reason for tagging WPA 11 something of 2025 is that the statutory appeal filed by the appellant as against the order of adjudication passed by the Bureau of Investigation was not decided on merits, but was dismissed on the ground of limitation. Therefore, if the learned single bench is of the view that the order passed by the appellate authority is not tenable, then the natural consequence that has to follow is to direct the appellate authority to decide the matter on merits.
No, sir.
This is the reason we have directed the said writ petition to be tagged along with WPA. No, WPA 1092 of 2024 and WPO 819 of 2024. It is made clear that this court has not adjudicated into the merits of the matter and all points are left open.
Much. Great. This is pending for so long, therefore I mentioned when I came across this.
Better you go there.
No, Lordship, because I will not lose one forum, Lordship. That is why.
Exactly.
That is much. Great.
If you succeed, they will be here.
Yes, Lordship.
If you lose, you will be.
Lordship.
You have to be there before your Lordship. Anyway.
That's all.
Just a minute.
Tomorrow also 11:45. Morning 6. Swearing in.